Ladies and gentlemen, welcome to the forum at the Kennedy School of Government. I'm David Breyer, the Director of the Institute of Politics, and once again, all of you are welcome as we begin winding down this wonderful academic year that we've had together. Many distinguished Americans and national leaders and international leaders and municipal leaders have come before this forum this year, and we're honored so much tonight to have Senator Orrin Hatch of Utah, the chairman of the Senate Judiciary Committee, with us. He is going to let us in tonight on some secrets about the Supreme Court. And so all of you take notes because you may want to refer back to those notes at the appropriate time. A couple of introductions. Mrs. Elaine Hatch. Elaine, would you please take a bow? We're so proud you're here. And the Hatch's son, Jess Hatch, who's a student at the Harvard Business School. Jess, welcome you. And tonight, in case anyone talks about the presidency or running for president, whatever, I think there are two people in this audience tonight who have sought the presidency. One is our distinguished speaker tonight. He may want to comment on that race. And the other is from the state of Tennessee, the Honorable Lamar Alexander. Lamar, we welcome you. And I understand that Senator Hatch has been, I believe, in your class this afternoon, and so I know the students have learned a great deal. Well, tonight we join in this discussion what may be one of the most important issues and perhaps one of the most contentious issues facing this particular administration. As many of you know, it has been 6.5 years since a vacancy has been filled on the U.S. Supreme Court. 3 justices today are over 70 years of age. Folks in Washington, D.C. are already mobilizing, and I must say, I don't miss all this one bit, Orrin. I had the privilege of serving with Senator Hatch for 18 years, and I can truly tell you he was a dear friend and a real good pal, and we joined together on some issues. I do not know one member of the Senate who has the unique ability, like Senator Hatch, of reaching across to the other side of the aisle and forming alliances and allegiances, as does Senator Hatch. Professor Mark Silverstein of Boston University, who recently was quoted in the New York Times, stated, "It used to be that a president looked at the opening on the court as this great and wonderful opportunity. It's so hard now, and there's so many different interests, that instead of this being a great presidential moment, I think it has become a great presidential burden," unquote. Senator Orrin Hatch of Utah is perhaps going to play a key role in shaping the destiny and the future of the U.S. Supreme Court. And before I turn the floor over to Jason Brenton, who is from Utah, to introduce our distinguished speaker tonight, I would like to say how very, very welcome we are to introduce and to have in our midst this very classy human being. He is respectful of others, he respects other viewpoints, and as of late, he has been getting an enormous amount of publicity about his songwriting abilities. As you see recently in the New York Times, here he is in your Utah home as he's sitting at his piano composing a new song. I understand about 10 albums, Senator Hatch. Jason Brenton is going to introduce our speaker tonight. Jason is a junior at Harvard College. He hails from the great state of Utah. He recently served as the president of the Harvard Republican Club, and we want to thank the Harvard Republicans for helping sponsor this fine event this evening. He started working in campaigns when he was 16, blowing up balloons for Senator Hatch's 1994 campaign. As a result, and as a payback to Jason. He was named as a Dole delegate from Utah in the 1996 Republican National Convention. He was the youngest delegate at the National Convention. It gives me a great deal of pleasure and honor to present to you Jason Brenton. Jason, come ahead.
Orrin Hatch grew up in the 1940s in a working-class suburb of Pittsburgh, Pennsylvania. Then the center of the nation's coal mining and steel production industries, his father worked as a metal lather and was a member of the local union. As a young man, Orrin Hatch learned the metal lathing trade and was a card-carrying member of the AFL-CIO. He worked his way through college at Brigham Young University, graduating in 1959, after which he entered the University of Pittsburgh Law School on full scholarship. As a law school student, he struggled to provide for his growing family, working with his father as a janitor, a metal lather, and at night as an all-night desk attendant in a dormitory. Now, after receiving his law degree in 1962, Senator Hatch became a practicing attorney, first in Pennsylvania, then in Utah, until his election to the United States Senate in 1976. Orrin Hatch had held no public office and was a newcomer to the political scene in a state where incumbent Democratic Senator Frank Moss was unopposed in his party, bidding for a fourth term in the Senate. Orrin Hatch entered the race on the morning of the last day to file for office against the advice of a party friend who told him that morning when he called in his decision, "Orrin, it's your funeral," to which Orrin Hatch replied, "We'll then send flowers." Now in his fifth term in the Senate, Senator Hatch sits on the Senate Finance Committee. Senator Hatch's expertise in judicial matters earned him the respect of his colleagues in the Senate and a position on the powerful Judiciary Committee. Since he's become chairman of the committee in 1995, Senator Hatch has fought to become a leader and has fought as a leader for tougher crime laws, civil justice reform, and for legislation to protect individual property rights. He also takes an active role in the confirmation of all judicial nominations, including justices to the Supreme Court, and believes that only judicial nominees who demonstrate proper judicial restraint are qualified for our courts. In an age when partisanship is thick, Senator Hatch has shown that politics can be put aside in working for the betterment of America. In many instances, he has reached across party lines, many times working with his friend Senator Kennedy. And many of you may not know this, but as Senator Breyer just announced, he's a gifted songwriter, as well as a pianist and a violinist, I understand. And I cut out an article from the Boston Globe some years ago that I think illustrates this very well. It's entitled, "Music Eases Way for Hatch-Kennedy Bill." People have been known to sing for their supper, but sing for a co-sponsor? During a recent negotiation session with Kennedy, Hatch insisted that Kennedy and his aide listen to his songs. Kennedy ordered his aide, Littlefield, to perform. Littlefield promptly then serenaded Hatch's chief health staffer with the song, "The Girl That I Marry." Hatch reportedly was stunned. Kennedy announced that Littlefield would learn the words to Hatch's latest song, "Freedom's Light," and perform it at the next negotiation session. He did, and the senators joined forces on that bill. With that, it's my greatest pleasure to introduce to you Senator Orrin Hatch.
Thank you so much. Thank you so much, Jason. That was so nice. And Senator Breyer, it's great to see you again, one of the truly great senators and certainly one of my friends for the 18 years that he was in the Senate. You're very fortunate to have him here, Governor Alexander. We've been friends for a long time. He's one of the great governors and, of course, would have made a great president had it worked out that way. But I just have to say you're very fortunate to have him here at the Kennedy School. This is a real privilege for me. You know, it was particularly nice to hear your kind words, both of you. But especially after what happened today on campus, a student came up to me and said, "You look just like Orrin Hatch." I smiled and I nodded, and the student said, "You must hear that a lot." And I said, "As a matter of fact, I do." The student then replied, "That must make you mad as hell." He said. Reminds me of my friend Ted Kennedy. When he found out that I worked as a janitor in order to get through Brigham Young University at one time, Kennedy said, "Orrin, you should have stuck with it," he said. Now, there's something special about being on a university campus, especially one as esteemed as Harvard. We're very proud that our son will get his MBA this May. And we have a daughter who's coming here to Harvard, a granddaughter, next year. So it's very important to us, and you've made me feel quite at home here. Whenever I visit a university, I can't help but remember the comment Dwight Eisenhower is said to have made when he left his post as president of Columbia University to become president of the United States. He left the university for the president because of his, quote, desire to get out of politics, unquote. I understand that there are members of the Kennedy School, the Law School, and the Business School in the audience, and I can't resist telling those of you from the Business School about my recent experience at a high school reunion. When I was walking in from the parking lot, I ran into a former classmate who struggled all the way through school and had barely graduated. He got out of a chauffeured limousine wearing a Rolex watch and one of the most expensive suits I'd ever seen. To be honest, I was really surprised, and I told him how thrilled I was with how well he'd done for himself. And he said, you know, Orrin, when we got out of school, my grades were so poor I couldn't even get a job. I ended up tinkering in my parents' garage and making these widgets. I never would have believed that these widgets would have done so well. He said, I can make a widget for $1 and then turn around and sell it for $4. He said, you have no idea what a difference this 3% makes. You can tell he didn't graduate from Harvard Business School. In all seriousness, it's truly an honor for me to be with you today to discuss my views on the future of the United States Supreme Court. In order to have a meaningful discussion of the future of the United States Supreme Court, it is necessary for us to consider where the court is today and where it has been in the recent past in terms of its ideology as reflected in its substantive decisions. Then I will offer some thoughts on what we might anticipate from the court in the future with regard to its ideology, particularly in view of the potential changes in the composition of the court. In the words of existentialist philosopher Soren Kierkegaard, life can only be understood backwards, it must be lived forwards. Once I've shared my views with you on the ideological future of the court, I hope I can have a discussion with you of what we might anticipate in the selection of justices to the Supreme Court. Before I launch into my views on the future of the court, I must confess that I have a certain degree of discomfort in making forecasts because history is full of examples of how perilous the predicting business can be. You may recall when Martin Van Buren, who in 1829 as governor of New York, you may recall that he wrote to the president, he wrote, the canal system of this country is being threatened by the spread of a new form of transportation known as railroads. As you may well know, railroad carriages are pulled at the enormous speed of 15 miles per hour by engines, which in addition to endangering the life and limb of passengers, snort and roar their way through the countryside. He concluded the Almighty never intended people should travel at such a breakneck speed. I'm also careful about making predictions when I think back to the year 1927, when H.M. Warner of Warner Brothers said, who the hell wants to hear actors talk? Or in 1977, when Ken Olsen, the president and founder of Digital Equipment Corporation, said, there is no reason anyone would want a computer in their home. Or more recently, the comment from the Yale management professor in response to Fred Smith's paper proposing reliable overnight delivery service. He said, the concept is interesting and well-formed, but in order to earn better than a C, the idea must be feasible. Of course, Fred Smith went on to found Federal Express. In any case, I will do my best to share with you my thoughts on the future of the court because, as inventor Charles Kettering once admonished, we should all be concerned about the future because we will have to spend the rest of our lives there. I would like to begin by raising this question. Can we expect our conservative Supreme Court to become even more conservative with potential upcoming appointments by President Bush? First, I have to take issue with the widely reported characterization of the Supreme Court as, quote, conservative, unquote. Indeed, I believe that any attempt to label the court as conservative should be viewed with a certain degree of skepticism. It is no secret that last term in the Supreme Court, decisions in a number of cases emerged with a more liberal bent. These cases demonstrate that the Rehnquist Court is not a consistently conservative one, but rather that it is comprised of shifting and sometimes unpredictable coalitions. Today, Supreme Court receives approximately 7,000 petitions per year, and last year it ultimately issued only 73. Of these, I would like to point out a few examples from the last term to just help us to understand the current thinking on the court and in turn to illuminate the future. On the point that it is inaccurate to characterize the court as conservative, and the point that it at times presents unexpected and shifting coalitions, I would be remiss not to mention Dickerson versus the United States. As you may recall, the court in a surprising 7-2 vote voted to uphold the so-called Miranda warnings, declaring that they were constitutionally based and thus could not be overturned by a congressional statute. The court held in effect that Congress may not legislatively supersede constitutional decisions. In the spirit of full disclosure, I should tell you that in the Dickerson case, I filed an amicus brief because I did not view the dictates of the Miranda decision necessarily to be required by the Constitution. The court has now spoken. In the abortion context, the court last term in Stenberg versus Carhart ruled 5-4 to invalidate a Nebraska statute banning partial birth abortions. As you know, the court held the statute unconstitutional because it lacked any exception for the health of the mother and because it unduly burdened a woman's right to choose. You may recall that in the earlier case, Planned Parenthood v. Casey, the court held that the state laws could limit abortions and abortion procedures so long as they did not impose an undue burden. Justice Breyer authored the opinion of the court, which was joined by Justices Stevens, O'Connor, Souter, and Ginsburg. Interestingly, Justice Kennedy, who was one of the justices who authoring the joint opinion in Casey that reaffirmed Roe versus Wade, authored one of the primary dissents. The other, of course, was authored by Justice Thomas. The dissenters contended primarily that the majority did not follow the precepts of Casey in concluding that the Nebraska law places an undue burden on the woman's right to choose. In the area of pornography, the court in United States versus Playboy Entertainment struck down a provision of the 1996 Telecommunications Act that was designed to protect children from exposure to sexually explicit adult programming on cable television. In again a 5-4 decision, the court ruled that this provision, which required cable operators who offer sexually explicit material to, quote, fully scramble, unquote, their signals or show such programming only between the hours of 10 p.m. and 6 a.m., violated the First Amendment's free speech guarantees. The court held that another section of the same law, requiring cable operators to inform subscribers that they will completely block objectionable programming if asked to do so, offered an equally effective and, quote, less restrictive, unquote, means to achieve the same goal. The court is always looking for less restrictive ways. And a 5-4 decision in Davis versus Monroe County Board of Education held that a student can bring a federal lawsuit against a school board for harassment by another student. Also on a 5-4 breakdown last term, the court in Crawford L. v. Britton made it easier for prisoners to bring lawsuits against prison officials. To those who would claim that the court is a right-wing court, poised to ignore judicial precedent and to revolutionize the law, I can't help but disagree. All of these decisions were forged with Republican-appointed justices who followed judicial precedent. And I should add, the same justices that the narrow special interest groups who opposed them promised us that they would not follow precedent and be right-wing conservatives. I had missed hearing from these groups over the last 8 years, and I'm sure they will find the Judiciary Committee address again in the near future. Once again, this is a court that reaffirmed the Miranda decision, struck down the Nebraska law banning partial birth abortions, and reaffirmed the central holding in Roe versus Wade. These are hardly conservative decisions, nor are they activist. Rather, they maintain the current status of the law. You may also recall last term in Santa Fe Independent School District versus Doe, the court held 6-3 that the policy of permitting student-initiated invocations prior to football games was coercive and violated the First Amendment. The court deemed such prayer not to be private speech, but rather an improper government-sponsored invocation at a school-related event. I think the Santa Fe decision that student-led prayer at high schools violated the Establishment Clause is particularly noteworthy when juxtaposed with Mitchell versus Helms, a decision from the same term. In Mitchell versus Helms, the court upheld in a 6-3 decision a statute that uses federal funds to lend educational material and equipment to both public and private schools. The court determined that the inclusion of religious schools in this program did not violate the Establishment Clause and that federal funds could be used to provide religious schools with educational equipment. Now, these and other cases that I have cited demonstrate that the court has no established orthodoxy or political agenda. Even the Washington Post noted, in an article after this summer's major decisions were handed down, that the court, quote, mixes its high-profile messages, unquote. Now, I recognize that some, particularly those in the academic community, will disagree with my assertion that the court is not conservative. But frankly, it is nothing new for Orrin Hatch to meet opposition from liberal members of the academic community. I am reminded of the time that Winston Churchill had finished a speech and a bystander asked him, "Doesn't it thrill you to know that whenever you speak, the hall is packed?" Churchill replied, "It is quite flattering. But whenever I feel too flattered, I always remember that if instead of making a political speech I were being hanged, the crowd would be twice as big." I'm afraid that's true about me. Given my premise that the court is not properly characterized as, quote, conservative, unquote, how should it be described? I believe that the court is decidedly centrist. We have a centrist court that is respectful of precedent, including liberal decisions of the 1960s and 1970s, taking important steps to restore more power to the states by defining the limits of Congress's legislative authority. The question then arises, if you accept my view that the court is centrist, whether the pendulum is destined to swing to the right when President Bush makes Supreme Court appointments. A review of the last term evidences a court that can at times be closely divided, with many 5-4 decisions. In fact, more than 1 in every 5 decisions handed down in the last term was 5-4. Last term, the court issued more 5-4 decisions than it had in previous terms over nearly the last decade. But if you'll bear with me, I would like to take a moment to highlight just a few of the more notable cases that were decided on 5-4 lines last term. In United States v. Morrison, which I will discuss in more detail a bit later, the court invalidated the civil remedy provision of the Violence Against Women Act. Now, I happen to be, along with Senator Biden, the author of that bill. The court ruled that the Commerce Clause did not provide Congress with authority to enact such a provision because the regulated activity did not substantially affect interstate commerce. You may also recall the court's 5-4 decision in Boy Scouts of America versus Dale, in which it held that New Jersey's public accommodations law could not require the Boy Scouts to hire a homosexual scoutmaster. The court determined that requiring the Scouts to hire a gay scoutmaster would violate the Boy Scouts' First Amendment right of expressive association. In FDA versus Brown and Williamson, something that both Senator Breyer and I were taking great interest in, the court held that the Food and Drug Administration does not have the power to regulate tobacco. More specifically, the Supreme Court held that Congress has not given the FDA the authority in the Food and Drug and Cosmetic Act to regulate tobacco products. First of all, the products under that bill have to be safe and efficacious. So how in the world could you ever give them authority when there's no way that you can prove that tobacco is safe and efficacious? The court upheld a death penalty sentence under a new federal death penalty law in Jones versus United States. The dissenters in that case would have invalidated the death sentence on a procedural challenge. Prince versus the United States invalidated a provision of the Brady Act that required local police to perform background checks on prospective gun purchasers. This case emphasized that the federal government cannot commandeer state officers or officials to serve federal purposes. Kansas versus Hedrick is another noteworthy 5-4 decision of that term. In this case, the court held that it was constitutional, to involuntarily commit people with, quote, mental abnormalities, unquote, likely to commit, quote, predatory acts of sexual violence, unquote. Also, the court decided 5-4 in Illinois versus Wardlow that police may stop and frisk someone who runs at the sight of an officer. The court reasoned that while flight does not necessarily indicate ongoing criminal activity, it can create reasonable suspicion sufficient to detain an individual. And in Kimmel versus Florida Board of Regents, the court held that state workers cannot sue the state employer in federal court for age discrimination under the Age Discrimination in Employment Act. The court held that the ADEA did not validly abrogate the state's 11th Amendment immunity from suit against private individuals, and thus the states may not be sued in federal court under the ADEA. What is significant of these 5-4 decisions? And what do these cases have in common? Certainly each of these cases presents difficult questions to the court, and all of them deal with controversial topics ranging from tobacco to the death penalty to guns. And I believe that we can take comfort in knowing that the very reason cases reach the point of undergoing consideration by the Supreme Court is because they are, in fact, difficult cases, and because intelligent people can disagree about them. We need to be very careful not to overplay the significance of 5-4 decisions, because I think it is very unwise to view the court as a political body, essentially as another Senate. Rather, I think it is of paramount importance to view the court in terms of its principled role within our system of checks and balances. Now, there's a lot more I'd like to say and a lot more I have prepared to say, but I think what I'd rather do is leave it at that. And then maybe just open it up for questions, and Senator Breyer would like to make a few comments before I do.
What I would like to do is just sort of lay the ground rules tonight for our questions. We'll go for about 25 minutes if we could, and we're going to let people ask one question each. We're not going to allow any speeches, if that's all right. So we will open up our mics. I know we have 2 floor microphones here. Do we have our microphones up there? We have 1, 2 microphones here. So we will rotate. We will start here, we'll go here, and then go back and forth.
Okay, I'll just take, is there some up there, you say? Or just these 2? Yep. These are the only 2?
No, up here.
No,
There's one up there, okay.
Here,
Then I'll go 1, 2, 3,
Thank
okay, you're first. Please tell me your name, where you went to school, and what school you're at here.
I'm here at Harvard, Senator Hatch. I'm a junior. My name's Ashley Keller, and it's a real honor to have you here.
Honored to be with you.
My question is this. With the Senate so closely divided 50-50, a lot of people are saying that the first Bush appointee to the Supreme Court is going to have to be a conservative, but at the same time someone who has the admiration and respect of Democrats in the Senate. And I don't think I'm the only person in this room who thinks that you are such a person. Would you consider a nomination to the United States Supreme Court if called upon by President Bush?
Well, that's a tough question. Let me just say that, let me put it this way. I think if I wanted to be on the court, I think Reagan would have put me there. So it's never been a great desire of mine to serve on the court. However, if you were asked, I think you'd have to serve. But I think it's very unlikely that they'll do that. So we'll just limit it at that. But thank you for your kind remarks. Yes. Yes, you're next.
Senator Hatch, my name is Alan Hassel, and I'm a citizen of Boston. I don't go to school here.
It's okay.
I wanted to, as a liberal, I'll admit that I'm that before I ask the question.
I used to be.
I wanted to ask if you...
Some say I still am. Okay, go ahead. I'm sorry.
There's always those. I was wondering if you could go into we often hear of conservatives speak of strict constructionist,
right.
And it's a term that I often get confused by because I see it as taken to mean different things at different times in my mind. And I was wondering if you could talk about strict constructionist views on religion. Specifically, you talked about 2 cases this past year that I look at probably different than you do. Right. One was about the school cases, the contributing of educational materials to the schools, and then the school prayer issue with the before football, with disallowing convocation before football games. I was wondering if you could go into what the constructionist view is on religion.
I can't do a very good job in just a few sentences, but let me just say this. Strict constructionists are those who want to interpret the Constitution rather to interpret the laws rather than make laws. Now, that's easier said than done. There are cases of first impression where you're going to have to make a final determination what the law really is. And that began with the earliest Supreme Court justices, and probably the most significant of whom, and one of the greatest leaders our country's ever had, was John Marshall in Marbury versus Madison. We have too many judges today that are creating law out of whole cloth. I think the best illustration is the Ninth Circuit Court of Appeals, Judge Stephen Reinhardt is almost world-renowned for ignoring what the law says and saying what he thinks it ought to be. And he gets reversed virtually every time by the Supreme Court, and with good cause. He's a very, very bright guy, but he's extremely liberal, and he basically believes that he should correct all the ills of society as a judge. Well, that's not the job of judges. Judges are to interpret the laws that are made by those who have to stand for re-election, those who have to be elected by the people. And that's what basically is meant by strict construction versus a more liberal approach towards the bench. But let me just say that it's very important that judges do not go outside of the realm of the judiciary, that they don't act as super legislators in black robes from the bench. Because if they start doing that, then the public is going to lose confidence in the judiciary. That's why it was important for me to point out these cases where, though liberal in nature, this so-called conservative court upheld them because this conservative court believes in the principle of stare decisis, which basically means prior precedent, the upholding of prior precedent as much as you can. And they believe in upholding the law as it is stated, even though some of them disagreed with some of those laws. So that's an important aspect of judging. We could spend all day just on that subject, but I hope that gives you just a little bit of an understanding. Yes? Or an answer to your question. Yes, sir. I'm sorry.
Senator Hatch, thank you very much for coming to speak to us here tonight. I think we're honored with your presence, and I think we'd all like to congratulate you and Senator Leahy with a great job and a very difficult job running the Judiciary Committee.
Well, thank you. I'm honored to be here in your presence.
My name is Harpal Alberto Coley, and I'm a junior at the college.
Okay.
And I believe people like myself, when we talk about the conservative Supreme Court, and many other Americans in the country do that, they mean particularly on the issue of federalism. And in particular, I remember Seth Waxman, who was leading a study group here, pointed out that he feels, as do I and as do many other people, that there was a commonly accepted standard for the relationship between the federal government and the states, and that this court has taken a very conservative position on federalism, and that in particular is what we mean by a, quote, conservative court, and that we've had many decisions, 5 to 4 decisions, dozens of them overturning federal laws in the last decade.
Those are good comments. In that sense, you might say the court is more conservative, because the principle of federalism is important also. Now, Seth happens to be one of the best solicitors general we've ever had. I did a lot to make sure that his confirmation was a smooth confirmation. He's one of the brightest people I know, and you're very fortunate to have him here. And I couldn't speak more highly of him. He's a great man and a great lawyer. But on the other hand, he liked the way it was, because almost anything was covered by the Commerce Clause. I mean, it was just anything, as ridiculous as some of the decisions were. If they alleged the Commerce Clause, it was uphill. And this court has said, no, there are some things that literally the Commerce Clause doesn't cover. And there is a right in the states. And keep in mind, from the beginning of this republic, there was a lot of concern just whether there's going to be an all-powerful, dominating federal government or whether we're going to have some rights in the states. Well, this court has been very careful to delineate that some of those rights still exist, even though they haven't gone overboard, in my opinion. Now, you might differ with one or more of those decisions, but the decisions are extremely important. I have to say that President Bush may very well appoint people to the court who might continue to make these fine distinctions between federalism and federalism principles and central government principles. And I, for one, think that it's the right thing to do. On the other hand, if it goes too far, we've got to make sure that the Commerce Clause is always a very important clause in the Constitution.
So are people like me being fair when we say that on that issue the court is conservative, or should I not say?
I think you can say on that particular issue it's conservative, but keep in mind, I'm talking about a broad base of 73 decisions were made by the last term. If you look them all over, then I think you have to conclude that, yes, it's conservative in some ways, it's liberal in some ways, it's basically centrist.
Thanks.
Yes, you bet. You're next.
Hi, Senator Hatch, up here. You can't.
You're next. I see. I didn't realize I had 2 up there. Okay, go ahead.
My name's Joseph Conzelman. I'm a freshman at the college.
You bet.
And my question to you is about the ABA's role in screening federal judges and especially Supreme Court nominees. My question is, why do some of your liberal colleagues, especially on the Judiciary Committee, complain that it was wrong to end the ABA's role, that they were a fair body after what they did to Robert Bork and how he was confirmed unanimously to the Federal Court of Appeals, and then somehow he became unqualified for the next level?
Well, by 4 of the standing committee. I have to say that it depends on your point of view. The Democrats love the ABA because the ABA investigations have been more liberal than conservative. So they love the ABA. Now, the all-time worst situation was Bork. Bork, when he was nominated and confirmed to the Circuit Court of Appeals for the District of Columbia, he had 100% well qualified, the highest rating you could have. When he comes up for the Supreme Court, 4 of them decided that he was unqualified. Now, here's one of the greatest legal minds ever in the history of this country, if not the world, and they called him unqualified, and 1 refused to vote. But the rest of them called him exceptionally well, or actually well qualified, which is the highest rating. And so politics entered into it. Now, where I come from is this. I don't want to ignore what the Bar Association has to say, but I don't want them to vet the judges. I don't want them to have the right of saying yes or yay or nay to the judges. That's our job. As senators, we're supposed to confirm. The president nominates. That's a greater power, in my view. We confirm or not confirm. That's a lesser power, but it's an important power, and it is the Senate's, not the American Bar Association. And unfortunately, we've had situations where the ABA comes back and says a person's unqualified when we know they are. I'll give you a perfect illustration. I led the fight for an African-American judge in Maryland that they called unqualified. Now, the man had tried all kinds of cases. He basically was a solid guy. He just wasn't an intellectual, but he was a good lawyer. And I led the fight to overturn the ABA on that issue, but that's the only one I can remember where we overturned the ABA in the whole 25 years I've been in the United States Senate. Why should the American Bar Association, when there are all kinds of other bar associations, from minority bar associations to women's bar associations and so forth, why should that bar association be giving some prestigious position of vetting judges? I don't think they should. But here's how it's going to work out. Tomorrow I'm going back and we're going to discuss with the Democrats on the Judiciary Committee how the blue slip system should work. Now, as you all know, that's a very complicated system where senators must return their blue slips to the Judiciary Committee, the senators in the state. This mainly applies to district court judges, but it might even apply to some circuit court judges. If they return a negative blue slip under the current philosophy of the Judiciary Committee, that is given great weight. In other words, let's say we have Bush as president, or let's use President Clinton. Clinton is president, you have a Republican and a Democrat in the state, and the Republican returns a negative blue slip. Should that be dispositive? It should be given great weight, but it should not be totally dispositive. And I think that's the way it's going to have to come down. But some of these people have taken the point that if the ABA is against them, they're against them. I think that's wrong. I think they should be judged on their own merits, and we should not let the ABA make that determination by itself. Again, who elected them? As important as they are, as much as they may give valuable advice, who elected them? Now, one last comment about that. This takes maybe I've taken a little more time than I should. Since the Bork matter, I do believe the ABA has done a pretty credible job. I don't have any problem, basically, with the ABA. I just don't think they should be a formal part of the process. Now, senators can give whatever weight they want to what the ABA findings are. Now, they've guaranteed to the Bush administration that they will bring in their findings within 3 weeks. Now, that I have to see that to believe it, but that's what they said. Now, if we find they're delaying judges out of pure partisanship, I'm going to get very upset about it because we treated the Clinton judges very well. And frankly, when you stop and think about it, for those of you who doubt that, let me just make this point. Reagan was had the all-time total number of confirmations by the United States Senate. Clinton was 5 less than Reagan. Now, Reagan had 100 more judges, too, to do. Clinton was 5 behind Reagan and would have been 3 ahead had it not been for Democrat holds. So he was treated very fairly. What's difficult is that you don't know why people are held up. Sometimes it's because of the FBI report, sometimes it's because of other matters, sometimes it's because the person's incompetent or just not qualified, and senators feel that way. Sometimes it's because they've done things they shouldn't have done. And sometimes it's just plain because the president, at the end of his term, loads up the nomination process with people he knows the other party cannot take, just for political reasons. To me, that's a very callous way of doing things, but it was done.
Thank you.
Yes, you're next.
Hello, Senator Hatch. My name is Adam Weiner. I'm a freshman at the college.
Great.
My question for you is whether or not you can call the court conservative. A lot of people would call it activist, in that it's been overturning a wide variety of congressional statutes. As you mentioned, for example, with the Violence Against Women Act, and a litany of others. But the case I wanted to ask you about was Bush v. Gore.
I was wondering why it took so long to get there.
I had to give it a fair introduction.
You did good, you did good.
As a strict constructionist, was that case properly a matter for the United States Congress, or was the court legitimate in stepping in?
In my view, it was legitimate, because keep in mind, the Constitution gives the authority over state elections to the state legislature, who in turn delegated it to the Secretary of State, who was found by the lower court finder of fact, the judge who was a Democrat judge, not to have abused her power. And then the Florida Supreme Court ignores all of that and says that, and basically overrules the lower court. Keep in mind, it goes up to the Supreme Court. I was there at that argument. The Supreme Court hears it, and may in a very soft way, because Justice Ginsburg said she didn't want to have these justices of the Florida court chewed up. Justice Ginsburg then, I think, had influence, and they, in a very soft way, said, okay, you got it wrong, but get it right this next time. It was a very nice reversal. And they turn right around and do exactly the same thing. Now, the court really had no choice. Now, let me pay tribute to a former Harvard law professor who's now in the court, Justice Stephen Breyer. And I had a lot to do with both Breyer and Ginsburg being on the court. They weren't on Clinton's list. I was the one who suggested those two to him. His number one pick was Bruce Babbitt, both times. Now, that's not generally known, but I think it's an interesting fact. But I was the one who suggested that these two would be slam dunks for him. I knew Stephen Breyer. Stephen Breyer was Ted Kennedy's chief of staff on the Judiciary Committee in the late 70s. When Reagan got elected, he had won the election, and Kennedy came and he wanted to get Breyer on the First Circuit Court of Appeals. And the Republicans said no. So he came to me. And I went to Thurman and I said, who was then about to become the chairman of the Judiciary Committee, I said, Strom, this isn't right. Steve Breyer's honest. He's extremely capable. He's a wonderful man. He's done a great and fair job as chief of staff on this committee, and we shouldn't treat somebody like that. He said, you think? And I said, yeah. And that's how he got on. That's how he got on the First Circuit Court of Appeals. And he's an exceptional judge, but I want to tell you why. It has to do with that case, why I felt he would be a very good justice. Because Steve Breyer really loves the Supreme Court. He knows how important it is for that court to be independent and for the judiciary to be independent. Between you and me, it's the judiciary that has saved the Constitution all these years, not the United States Senate or the House of Representatives. We write things all the time that would undermine the Constitution. I mean, I hate to tell you, it's the court that has done it, and the other courts in this land. Well, when this case came before the court, this final decision, I was there also in that argument. And I have to say, the important decision was finding a violation of due process and equal protection. And that was the 7-2 decision that I think protected and preserved the court's reputation. Now, Steve couldn't go far, I shouldn't say Steve, but Justice Breyer couldn't go far, we're good friends, but he couldn't go far enough. He just couldn't bring himself to do the remedy, which was 5-4. But because of Breyer and Souter, arguably the most liberal justice on the court, appointed by George Bush 1. The fact of the matter is that because of those two, I think it preserved an awful lot of the court's image and prestige. And it was a hard thing for Justice Breyer to do, but I admire him for it, and I was counting on him being that type of a justice. I don't agree with Stephen Breyer in a lot of ways. And he doesn't agree with me in a lot of ways. Maybe that's a better way to put it. But I do think he's a marvelous legal justice. And I think he rose above politics to vote the way he did. And so did Justice Souter, who deserves a lot of credit. Okay.
Hi, my name is Katie Glansmith. I'm a second-year student at the Kennedy School.
Yes, sir.
My question follows up upon the last one. I respect what you said tonight about the Supreme Court needing to be perceived as a non-political body, that it shouldn't just be another
It can't be totally perceived that way, but it is. I think it's important that we look at it more as apolitical.
I think I'm probably among a lot of Americans who feels a new cynicism after the Florida proceedings, and a lot of the implications that many of the judges might have had personal political stakes in that decision. I'm curious if you could speak to a perhaps changed image of the Supreme Court after those recent decisions.
Well, to be honest with you, I was surprised that the Supreme Court didn't just slap down 9-0 the first decision by the Florida Supreme Court. It was so clear to me. And I felt that the second decision, it was a shame that 2 justices held out, because it was important for the court. And I believe that the law is pretty clear on it. You know, you had standardless ballots that had never been counted before. And you can't change the rules of the game after the election. You might be able to change them before, but you can't change them after. And that's so clear. It's clear as a bell to me. And if it had gone for Gore, I would have been for Gore on that matter, because I don't think it really came down to politics or whose politics were involved. I think it did come down to the law. And the law is pretty clear. But then again, you know, there's always room for disagreement in some of these areas, and that was a hotly contested area. But, you know, the greatest thing about it is, look at our country. This country survived that. I mean, almost immediately people accepted it. Yeah, a lot of people were, like yourself, felt badly about it, felt aggrieved. On the other hand, we've accepted it. We've gone forward. We didn't have riots in the streets. And this country is the better for it. And I think it shows what a marvelous Constitution we have, and what a marvelous legal system we have, and what a marvelous political system we have. Now, you know, you get into standardless ballots, and who wins and who loses based upon interpretations by people who are partisan. That just doesn't compute quite right. And but I can see both sides of this issue, and fortunately, many Republicans believe that the recounts since have shown that Bush won anyway. But I think you could have, by partisan findings, have gone maybe either way. Although I did feel that Bush legitimately won the state. And I think you saw both sides arguing that some ballots should be discontinued, or some ballots should not be counted. And it got really bad when they weren't counting overseas service people's ballots. I mean, that was ridiculous, but that's the way the partisanship got so bad down there. But nevertheless, the important lesson out of all that is that our court did rule, our court was accepted, our country did survive, and we did so without riots in the street. And it's an example to all the rest of the world what a real representative republic can be. Okay? Yes, sir.
Senator Hatch, my name is Lucas Tate. I'm a pre-frosh here at Harvard University. I'll be attending Harvard next year. I return home to Arizona tomorrow.
Oh, great.
Back home among the tumbleweeds and rattlesnakes, we have a hotly contested debate over religious clubs in elementary and middle schools. This debate has been carried to the state legislature, and there's a bill pending to allow those types of clubs. There's also a decision right now before the Supreme Court that they've agreed to review regarding religious clubs in middle schools. I believe it was the Good News Club that is being decided on. I believe it's the Mitford case. Do you see the future, I guess my question is, how do you see the future of the court regarding religious clubs and religious activity in schools, high schools, middle schools, et cetera, both now and after the Bush appointees that you see in the future?
Well, the dividing line is whether they're trying to impose particular religious beliefs on the minds of impressionable school children. Nobody wants to allow that. On the other hand, where this totally student-led and student-operated and student-controlled, there have been some matters that have been left up to the students. But that's why this case was very interesting last year, where they said that student-determined invocations at football games should not be permitted. That was a very interesting case in light of the prior case law in this area. All I can say is the Founding Fathers weren't concerned about religion, except they didn't want a state church. They didn't want the government imposing religious beliefs on the minds of anybody in our society. That was a very principled position. But they would be amazed if they came down here today and saw our arguments about whether we can pray in school or even have silent prayer in school. You know, they would be absolutely, they would be mind-boggled over the way this has become such a technical issue when they actually raised money to support missionaries to the Northwest, in the Northwest Indian Treaty. Northwest Ordinance, rather, they raised money to send out missionaries to the Indians. So, you know, I think sometimes we get too caught up in in ideology and not caught up enough in what's right. But we're there, and I'm not sure it's going to change because of stare decisis, which is a principle that literally is a very important principle. I guess we'll take you, and then maybe one more after that, and then I've got to catch a plane.
My name is Mike Weissman. I work here at the Kennedy School. You've made some comments at Judiciary Committee hearings about the possibility of compulsory licensing for digital music should major companies in that industry fail to develop a market for digital music for music fans. In the past couple weeks, the big companies have made some announcements to that effect. It's not entirely certain how that's going to play out. I wonder what your views are on the role of the federal government in ensuring music fans' fair use rights in the light of technologies that can increasingly take away those rights. And I wonder, suppose a case regarding fair use rights in digital media were to come before the Supreme Court as it's currently constituted, how do you think that would turn out?
Well, I don't know, but let me just say this. We're pretty well solid. We have a pretty solid set of laws on fair use right now. It may be that those laws have to be changed. All of this arose out of the Napster situation. But because of the hearings that we've held, the 5 major recording companies have been kind of pushed to licensing. And they even said in this last hearing that they would license Napster if they can have a way of making sure that there's one download, but no more after that. Napster feels they can do that by the end of July. If that's so, Napster will become a very, very important, it's important now, but it will become a very, very important mechanism through which you can download music. Now, I think there is software available where, or at least can be available, where they can basically watermark the future downloads other than the first fair use download in your home. But you pay for that first fair use download because copyright is one of the most important aspects of the Constitution, one of the specifically mentioned items in the Constitution. And intellectual property is very important to this country. It's the one area where we absolutely have a favorable balance of trade. Our entertainment industry, music, books, movies, television, and so forth, we export a lot more and we get a lot more revenues than we do costs out of it. And all I can say is that I don't want to go to compulsory licenses, but I said that to try and push the companies into resolving these problems. There's a dichotomy of philosophy on Napster. There are those in the industry who want to kill Napster dead. And the reason they want to is to set an example to all others who might infringe on copyright rights. Now, I think that's too far. I've said that they should capture Napster. When you have an entity that has over 70 million people who have come into it, it seems to me that's an advantage to that industry. The industry is still living in 1695 CD world. Within the next 3 years, it's going to be downloading of individual songs for an individual small price for which a royalty will have to be set aside for the writers of music. And that is for the music composers and the lyricists. But as you noticed, if you watched the hearings, the last set of hearings, Don Henley testified, nobody takes care of the artists. And you know, the artists are the people who really sell the copyrightable material. So he's raised an issue that's very, very important. Are they going to be taken care of on the internet? These are complex, very difficult issues. I don't have the answers for them, but I'm sure as heck pushing everybody to try and come up with answers. I don't want to go to compulsory licensure because that means the federal government will interject its almighty hand of power into a system that has worked quite well up to now, but which is in a state of flux where we don't know where we're going. But it's important for all of you, especially young people, who really want a world where you can download anything you want to download. But if you're going to download, you're going to have to pay for it. Now, it may be a reasonably small fee compared to what some people would like to have, but you're going to have to pay. Otherwise, we would have no creators, and really, you'd ultimately have nothing to consume. The two most important elements of copyright are the creators and the consumers. The middle people are going to make money no matter what if they're smart middle people, if they really are smart in business. And there are billions of dollars to be made in music. But I have to tell you, writing music myself, let me give you the phone number where you can writing music myself, it's a very complex area. As you know, I'm a member of the Church of Jesus Christ of Latter-day Saints. We've been nicknamed Mormons throughout the years. Well, there's a lot of prejudice against Mormons out there because they do not believe that people who belong to the Church of Jesus Christ of Latter-day Saints are Christians. Now that's kind of strange, isn't it? Because we're very devoted Christians with a very big appreciation for faith, for all faiths. I wear a mezuzah every day to remind me of my need to do what's right in the Middle East, and particularly with regard to Israel and the moderate Arab states. But I found that it's awfully difficult to sell my inspirational music, which most everybody listens to says is very good. In fact, it's not only very good, it's the best you can get. And I have to say, because there is a certain amount of prejudice against Mormons, they don't believe we believe in Jesus Christ. Well, that's ridiculous, but that's how some people feel. So there are a lot of nuances in this recording area, but it's a wonderful industry. And whether or not anybody ever buys my music, and they do, but whether they do or not, it's a wonderfully uplifting thing for me to do. Now, just so you don't think I'm just totally an aesthete, I used to fight as well, and I was offered to turn pro as a boxer. I was that good. Of course, I was 6'2" and only 147 pounds, and the guys I fought came up to hear on me. But I was a tough kid. I was raised on the wrong side of the block, and when I carried my violin to school, I had to fight my way through every time, and I got to be the toughest kid that ever lived. But one thing's for sure, my folks would they would scrimp and save till they could get $18.75 every year, so I could get season tickets to the Pittsburgh Symphony Orchestra. And I would run 2 miles, catch a streetcar, go to the Syria Mosque, sit in peanut heaven where I'd hear the greatest artists in the world. Fritz Kreisler, Jascha Heifetz, Roberta Peters, her debut, you just name it. And I would hear the greatest artists in the world. And then I'd take the streetcar back, run 2 miles home, get home well after midnight. But I did that for 6 solid years in high school. It was really, really wonderful for me. So I take a great interest in this area, and I'd like to see you young people come up. I'm going to challenge you. Why don't you come up with a way that we can keep Napster alive and servers like that? Because look, the next bet is Nutella. If Nutella worked as well as Napster, Nutella does not have a central server. And there's no way you can control what goes over Nutella. But with Napster, it has a central server. And Napster can become a major, major force in the music world, and a major force for good. At least I believe they can. We'll have to see how it all settles out, but it's certainly got to be interesting to all of you. Well, I think Elaine and I better catch our plane, because I do have to be with those Democrats tomorrow morning. You don't have to be with them. You can have a good life. Thanks so much. Great.
Well, Senator Orrin Hatch says that, and I quote, "We have a marvelous political system," and I can tell you he has made it a lot better tonight for all of us. You've given us a great insight, Senator Hatch, into the Judiciary Committee and into these decisions that are forthcoming. Thank you very, very much for being with us. Very quickly, the Al Sharpton debate that was scheduled for tomorrow night has been postponed until the following Tuesday night. But Thursday night, we're going to have the China incident, press, policy, and diplomacy. I think all of you will enjoy that. Friday at 4 o'clock, we're going to have Fidel Ramos, the president of the Philippines, from 1992 to 98. And next Monday night, we will have Rosalind Carter. So we have a lot of great speakers coming. Thank you so much for being here tonight. Thank you.
I think Senator Hatch wanted me to take that speech
You
and
want to
publish it.
Yes.
Thank you
For
very
the-
much.
For the law school?
Yes, exactly.
That's it. He just,
Thank you very much.
He just asked me to make sure. I'm glad
It's
you
so
were here.
kind of him to remember as well.
I'm glad you were here.
I'm
I'm glad you were here to take it because I didn't know what to do with it. Thank you very much. Now you are with the law.
Yeah, I'm with the Journal of Law and Public Policy. It's actually for the official Journal of the Federalist Society, which probably why is
This is really
between the Federalist Society and the Republicans, we sent out emails to probably 200 people. We probably got about half of them, I think.
This is a wonderful crowd. I don't know where you seated, but they were all the way to the top.
Very excellent. Thank you very much for putting this on.
Yes, sir.
Very nice to meet you.
Thank you. Come back and see us. We had some good shows. Stop by a couple of times. You did. You stopped by the home. Are you hearing me? No, does she have a